Item number 2 on the agenda was parliamentarian for board meetings, and a couple of board members had requested this, but I know that Mr. Cordell had used a parliamentarian when he was mayor, so you're going to go ahead and lead this discussion?
Okay. What, 2 minutes?
Yeah.
No.
We'll give you 3.
Thank you. Mr. Joe Pettigo has been our parliamentarian in county government for years, sitting next to me doing a great job. And I talked with Ben Torres regarding the many counties and the many school districts have parliamentarians, and he said not many do. And I know Mr. Pettigo has offered, been there as a consultant for years and is still willing to do that. And I talked with him, he does not want to be full-time or whatever in that role, but he is still willing to consult and do consultation with us. So Mr. Torres said that's the way many counties do that, and that may be the way we want to proceed for the time being. But I just want to give you an update on that, and been researching that some, and anyway, but not many counties do that, or not many school districts.
So how do you employ the parliamentarian? So explain how that works in
County government?
Yeah.
We just have an
Probably
agreement.
here too.
I'm not sure about in the school
But
board area.
did we not
I say we
just
just have a,
staffing? You know, like
we just
for
pay
each
him amount.
meeting?
I know in the past, we've been paying, the county was paying him $100 per session. And of course, he, bless his heart, he turned it over to the FFA program. But he, I don't know what the cost on it would be, but I know there we've been paying $100, but he would be there as was there sitting, there as a parliamentarian. Robert, you have any?
Yeah, he still does that for the county,
Yes, he
but
does.
he was, for
Yeah.
us, he would, he told me he would consult anytime anybody had a question or wanted to, if they needed an answer on something or proper procedure, stuff like that. But as far as attending other meetings, or
Right.
every meeting and all that, he was not.
He's not in favor of that.
Yeah.
But he did talk about, there, go with their, primarily, I guess, with their board chairman.
I don't know about y'all, but I feel like that if we had a parliamentarian other than one of us or the director or whatever, or the deputy director, it's someone that's not involved in the meeting that is telling, giving us instructions, and that we're not instructing ourselves, or the director's not telling us how to word something, or that we did something wrong. It would be the parliamentarian. And I know we were lucky to have Mr. Pettigo
Yes.
through the years
Yes.
as an employee, so I'm sure he didn't get paid any extra in his duties. I think he was deputy director then, and but he's got a lot of experience in that.
Yes, he does.
I hadn't talked to him or anything,
Yeah.
but I
Yeah.
mean, I was just thinking if he would be willing to do it at our regular board meetings, and at least.
No,
He
that's
does not
what
wanna
he
do
said. That's what he told
Mr.
me.
Pettigo doesn't want to do it?
No.
Oh, okay, I thought you said somebody else.
No,
No,
No.
he doesn't.
Oh,
He
okay,
doesn't
well,
want
that
to do
was,
that.
to me, the helpfulness would be at the meetings,
yeah, it would
my
be.
opinion.
And I know Mr. Torres would, told me when I talked with him that some counties, in many situations, the chairman will have parliamentary understanding and moderate or give advice or whatever, or decide on some issues, whatever. But in some counties, some districts, they have one of our board members that has parliamentary procedure understanding, whatever. They would rely on that person to provide consultation or make decisions or recommendations during the board meeting.
So would they run the meeting and Thomas wouldn't? Like what would they exactly do? I'm sorry. What would they do? Do they run the meeting? Do they call it to order, or do they just correct us if we're wrong, or
I
how
think the chairman would call a meeting.
Yeah.
Yeah,
I just don't
But-
know exactly the role of this parliamentarian.
Explain what a parliamentarian does.
Evaluates, rules on, makes decisions on different procedural issues, motions and whatever, and gives guidance in the way to do motions or amendments or whatever. Serves in that role.
Makes us adhere to Robert's Rules of Order.
Yes.
This is really what it comes down to.
Right.
So,
certificate to the, state school board, Tom?
I don't know.
Yes, ma'am.
Yeah.
It is? Okay.
It
It
is
is.
on there, and I think it's free that you can take online courses there. All you have to do is sign up.
Oh, well, yeah, you know, but for an actual parliamentarian, an actual parliamentarian can get certified to be parliamentarian, so, you know, any of us can take the Robert's Rules of Order classes, but, and, you know, I've kind of been diving into that too, but for an actual parliamentarian, I think they get certified, and so so there's a distinction between somebody acting as a parliamentarian and an actual parliamentarian, the way I understand it.
Well, excuse me, Mr. Chairman, there are 3 or 4 levels of that. There's a registered parliamentarian, which is somebody who's taken the test and passed it. And there's a certified registered national parliamentarian, which you have to pay those folks
Yeah.
to come in your meeting. And they do things like the conventions, the political party conventions, the Southern Baptist Convention, the League of American Orchestras national meeting is, there's a certified registered parliamentarian sitting there with them. The role of a parliamentarian is not to run the meeting. The role of a parliamentarian is to advise the chair in the event that there's a question about procedure. The parliamentarian, for all intents and purposes, should be just about invisible at a meeting. You know, we don't, and I've served as a parliamentarian, you don't speak unless spoken to. And if there is a point of order, the parliamentarian addresses the chair, never the audience or the body. So that's the thing. 2 things to remember. There is a case in Tennessee that says, unless parliamentary procedure is a problem, is a big problem. There's a case in Tennessee that says we're going to look to the intent. The courts are going to look to the intent of the board on the action that was taken. They're not going to look to see if the niceties of parliamentary procedure were followed. They're going to look to see if the intent of the board was followed, and is that expressed in the minutes of the board. So having a parliamentarian here is a fine thing, but if it comes down to a court case, the court's going to look to see what the expressed intent of the board was, regardless of whether we followed the strict rules of Robert's Rules of Order.
Thank you
That's
for
a
the
good point.
clarification.
Thank you.
So if we mess up, it's not that big a deal.
No, it's not. It's not. And, you know, we've tried a lot of cases, on this, and where somebody will raise it. The most recent case that I tried several years ago was out of Roane County Schools. And that was one of the things that the lawyer raised, and the chancellor didn't even hear it. I mean, you could see the chancellor just turn off at that point when he was arguing that they didn't follow Robert's Rules of Order. And the chancellor finally asked at the end of his argument, does anybody ever follow Robert's Rules of Order? And I will assure you they don't. They don't. And as hard as the State House of Representatives tries, they go askew every now and then. The State House follows Robert's rules. The State Senate follows Mason's rules of legislative procedure. So when you go into that forum, you have to be familiar with 2 different sets of rules. But nobody really ever follows them. And it could complicate things if you did. Again, the courts and the public are going to look at what was the expressed intent of the action that the board took. Did we necessarily go back and follow Robert's rules as we were doing it? That doesn't really matter to the court. Is it a legal action, and did we get there reasonably?
Okay. Just keep things from becoming chaos, I guess.
Yeah.
That's really what it comes down to.
Now, if you get into motions to refer to a committee and motions to motions to withdraw amendments, to add amendments, amendments to the 3rd degree, things like that, it is kind of handy to have a knowledge of Robert's rules about that, because you can't have an amendment to the 3rd degree, for example, an amendment to an amendment to an amendment. You can't have that. I play parliamentarian occasionally, and believe it or not, I do attend church as a lawyer. But I play parliamentarian at our business meetings occasionally, Wes Turner and I, and Wes is parliamentarian for the Tennessee Baptist Convention. And we can get in some messes in those meetings. So as long as you have a passable knowledge of it, and there are some cheat sheets that you can use about parliamentary procedure. We've developed some of those when I was 1,000 years ago when I was at TSBA. and we can pass those along to you. And there's a little Cliff Notes version. You don't have to carry Robert's Rules newly revised in the meeting with you. There's a shorter version of that as well, that all you gotta do is open it up and refer to it as you need.
So, the question is, do we need a parliamentarian or not?
I think with having good people that you back and call for strategic moments, I think we're quite fine just knowing we have that on the back doorstep if we need it.
Right.
I think we could navigate the waters.
Yeah, those cheat sheets, I mean, Melissa, you made us a cheat sheet a few months back, so,
You know,
okay,
if everyone could practice a lot of the etiquette on their own, that'd be great.
yeah. I know we've got in confusion sometimes with
Yeah.
motions and secondary motions and things like that, so, at different meetings, but you're telling us that's not gonna become a legal issue for us.
It's not gonna become a legal issue. It's, but I like it when everybody understands what's going on.
Right.
That's the great thing about parliamentary procedure is that you're assured that everybody knows what they're voting on, at the time. And as long as you're somebody who can keep up with that. I'm usually available by cell phone. Several years ago, a school system that shall remain nameless in Upper East Tennessee called me about 8 o'clock at night. I was driving home from Chattanooga, and I sat on a rest stop on the interstate for about 45 minutes advising them through a parliamentary situation. It was a mess. It was a mess because they weren't sure what they were doing. That's the good thing about parliamentary procedure. It does help folks keep straight what's going on.
And I think one of the not hardest things, but one of the things that new board members, and I'm talking to myself, was realizing that we do not speak until after a motion has been made and seconded, and that's when the floor is opened up. And, with most business people or anybody's not used to that. They're just, something comes up and talk about it. And, so that's basically, as long as you do that.
Yeah,
Yeah, that's the hardest thing that I think we still to this day we do a lot of talking before we get a motion made.
and I think the other thing we struggle with sometimes is properly formed motions too, so that's
Yeah.
kind of, getting that right. So that's where somebody might be able to advise us, but I don't know if that comes up that much, so. It might be good just to, we got Mr. Cagle as a resource, and Mr. Pettigo, if we need to consult him. I mean,
What if we had
He
one
knows
for
his stuff.
What if we had one for like 6 months or so, just to get us through some meetings, see how the meetings would go?
we could, we could do whatever
Just an
we
idea.
want on that.
That's
If
what
Mr.
we're all here
Pettigo
for.
isn't available, then we'd have to find somebody, and I don't know who else is available here as a parliamentarian to attend the meeting. But we could look.
That's just an idea. Kick it around, to get everybody aware of what's going on, get them used to using it.
Yeah. It's a possibility, I mean, it's, if we hired somebody, that would have to be an agenda, I think. So, question is, do we wanna put that on the agenda?
I would say sitting in that room over there for 8 years, in the, sitting there as mayor, it was critically important to have a parliamentarian. He kept us out of so many, advised us on so many topics, whatever, it was amazing. And maybe kept us out of lawsuits, who knows? But he was brilliant in that role, and I relied on him so many times, every time. I wouldn't even thought about sitting in that chair, knowing what I know now, without the parliamentarian. That was so critical in that role. I know it's a different role here, but
I mean, Mr. Cagle, what do you think about, if we had one for, start us out 6 months or so, just to get everybody, especially as me, you new members, to get them used to working with the parliament, with Robert's Rule of Order, and it's just an idea, guys. I mean,
I think
What
it's
we're
either,
here
I think it's good either that you get training in parliamentary procedure, or that you have somebody in the room who can, train you by acting in that role.
Sure, that's what I'm talking about.
Yeah, it's either one or the other. And it's always good that everybody pretty much knows what the rules are. I often say that the best fights in the legislature are not the ones over the bills, it's the ones over the rules. And the best fights in the courtroom are the ones over the rules. They're not the ones over the substance of whatever case we're trying. But it's, where the rules of evidence and civil procedures say, and parliamentary procedure is virtually the same way. If you get somebody in a group who really knows parliamentary procedure, they can mess you up in a hurry. It's good to get the training by example, and either that or take the course. So the training by example may be beneficial for you.
Yeah, that's what I was thinking, is words, actions speak louder than words anytime. You can train, do all kinds of training, but if you have somebody to actually go through it for a little while and get you started.
Well, we'd have to find somebody. Mr. Pettigo is not available, as we know, so we'd have to find somebody that could play that role, and I don't, you guys know anybody? No? So, we could research that and then put that on the agenda if we wanted to do that. And
What we would need from a perspective to put on the agenda for a board meeting would, if we don't have somebody in mind, like Mr. Pettigo would have been a natural fit, we would need a job description, we would need approval of the board on compensation, and approval, to move forward with it. So that could be on a future board meeting, but we would have, in order to post it, we would have to have a job description.
Right.
This is, and I don't mean to break in here, if this is a contract position, you wouldn't necessarily have to post it.
We wouldn't have to.
That's right. You wouldn't have to post it. If the board located somebody that they could use, it'd be a professional service. You wouldn't have to post it.
Great.
Yeah, that would just be a per meeting basis. So,
Yeah.
Okay.
But it would still be an agenda item that we'd have to,
Yes.
Tom, do you think just to begin that maybe Mr. Pettigo would be willing to meet with us and like do a class for us? To get us started?
I think TSBA already offers that
Yeah.
service.
And I really think, I think we do a good job of it. It's just sometimes wording the motions and that sort of thing. And, to me, basically, it's just knowing that you have to address the chair to speak, and that a motion's gotta be made and seconded before you do that. And I know I've been on other, and I know you have too, I've been on other committees, government committees, and it's not necessarily followed that way. So that's why it was kind of different to me when I got on the school board, because we talked. We didn't have, we didn't have a motion and a second before we discussed things. And then on the school board, it's entirely different. So it's according to what you come from. And I think all of us, we've done well the first meeting.
yeah, I think so.
We can see if we can find, someone that would be, maybe Mr. Pettigo came to one meeting, maybe our next meeting, and just see how he's like, I don't know, just a thought. Would he be willing to do that?
Maybe,
You do one?
maybe.
And just see
All
how
right.
bad we are. But I know that, Mr. Cordell is correct about what he was saying about, the local government. I don't know how you could have.
I wouldn't even think about it.
Mhm.
Wouldn't even think about it. My goodness. That was so critical.
Well, part of it will be, TSBA does offer, as Dr. Lawson said, TSBA does offer Robert's Rules of Order classes. There's some online webinars. And I believe at the convention, they also usually have a breakout session that talks about Robert's Rules of Order. So it's getting the basics down. I mean, yeah, like Mr. Cagle said, the book is about this thick. It's not something that you read cover to cover. So, for sure. So that's, if we want to get Mr. Pettigo to come to a meeting,
You mean invite him to
Yeah.
come for when?
to evaluate it, that would be, we'd have to, I don't know if we'd have to do an agenda item just to invite him to a meeting, but. So we want to leave it at that?
Joe Petty Pettigo's who taught me.
I was gonna say, anybody who's been through FFA usually
Has been.
is a great
I actually
competitor.
competed at state level.
Wow,
See,
think I
look
did
at
really
you
well.
there.
brilliant, brilliant.
Yeah. I know you pipe up about that. All right.
I'll call
Mayor
him.
Rabbit told me in that
All
fire
right.
patch.
So, third agenda item, board meeting agendas, format, and board meeting times. I kind of put these two together because one kind of impacts the other. So if we change the board meeting times, then we may want to shuffle the agenda. And so, Mr. Cordell and Mr. Hansert wanted to talk about meeting times. So, Mr. Cordell, you can start.
On discussion about the agendas.
Yeah,
Okay, well, you have in your packet some information that I attended a webinar on TSBA webinar, 7-hour webinar, and it was great. I think they covered 140-something pages in that webinar. I mean, not all the topics or whatever, but that was, in that webinar, there's at least 140 pages in that. But on board policy and operations, we did that in April or June, I can't remember when it was. But it was a great webinar. I encourage everyone to be attending and listening in those webinars. And you've got a schedule already for those coming up for this year. And we learned so much in that. And I just want to share that with you. But one topic that really perked got my attention was the discussion on agendas. And I don't know if coming in as new board members we had any information or whatever on that. But I know and you've got that in your packet there somewhere. On page 78 in the board policy and operations discussion we had, agendas. In order for a board to have control over its meetings, it must first have control of its agenda. An agenda gives a meeting structure and a sense of direction. And you can read all this later yourself, but it's so much information in there that we need to know. The agendas we know are important. I didn't know anything about the background, the structure, how the process in putting items on the agenda. And I have done some research. I talked with Mr. Torres and Brittany regarding getting some copies from other counties and whatever. So you have, thank you, Melissa, for printing those and all that. You have a copy there, for example, on in your packet. I think it's in all the packets about a agenda for September 9th for Manchester Board, and then Murray County, and then there's one in there somewhere, Hickman County, and there were copies, I think you got another county or two somewhere, but there were agendas in that we reviewed on Rutherford County. I chose not to ask Melissa to put that one in there. It was page after page. I couldn't believe getting way down into the weeds on that one.
there's 42 pages of consent items.
Oh, it's unbelievable, but anyway, and we did ask for some copies of the on Board Effect link that I got, and we can't read the copies on material on that, but anyway, but that was for, I can't remember the counties involved in that. But I just want to give y'all some samples to let the board know how critically important it is, and we have a policy on agendas, but how critically important it is for the foundation, the structure, and what goes into the meeting. And I wanted y'all to have some different ideas or look at some different samples from other counties. So going forward, we could review that and whatever. But that right there, I would encourage y'all to really get into that. On the TSBA Board Policy and Operations, there's about 3 pages there on agendas, starting with page 78. But with that, I'll shut up. And, part of that's on supporting materials, consent agendas, annual agendas, how to develop an annual agenda, and so much stuff in there that will be helpful to us.
And we do, Melissa did insert policy 1.403, which is our board policy for agendas, but it's not real specific on the order of agendas, just some things that need to be included. So that's in the packet as well. But, before we open it up for discussion, did you have any recommendations on how you wanted to change the agenda?
Not at this time. So I just wanted to put it on the table, see what your thoughts were. And give you some samples there to look at, and then maybe at another time we can review that and on whatever and come up with ideas at another board meeting.
Anybody else about agendas?
Just one thing that we definitely do need to look at the layout and the format. We need
Yeah.
unfinished business stuff that gets moved from a prior meeting to before.
Yes.
Because I ran in, believe it or not, I received a call, and then I ended up having to call Mr. Pettigo. That's how I talked to him about some things going on here locally in local government where some members are not showing up so that they don't have a quorum. Normal business is getting blocked of the government agency, and it's kind of like one of those, look, get the meeting going, as long as you gotta have a quorum to conduct business. So it's not necessarily a quorum to start the meeting, you must have that to start the meeting, but then the first motion, you gotta have a quorum to have a vote on it. If you get to the last one and somebody gets up and goes home, and you don't have a quorum, then that goes as unfinished business to the next.
As a board member, I want us to first look at options and make sure we're putting the best agenda forward we can for the benefit of our faculty, our teachers, and our students. Make sure we're doing it right and covering all
I'm
the
not saying
topics.
we'll run into that circumstance like I was saying, but you never know.
Well, another thing I think is important as a new board member, the consent agenda, that sometimes there are things that you really need to take, pay attention to on the consent items. A lot of them are just like, routine meetings or something to the high school or the schools want to go on a field trip or a sporting event or something. Those are, sort of minor, but sometimes in policy, because that's sometimes the only time that other board members see that policy, but you're not on that policy committee, and it's very important for you to know what you're passing.
Yes.
So, if there's a policy in there that you understand, it needs to be pulled out.
We do
And
good,
put on
we
the
do
regular
good
agenda.
about that, and that's,
Yeah.
some of the new folks, that's really good about, making a motion or amendment to pull that out and then pass the general consent items.
Yeah, that goes on the agendas at the end of the agenda, then you pull it off the consent agenda. So,
And make sure we have all in advance, all the documentation we have, so we can review that as board members days in advance, so we can come to the table prepared.
and technically, according to Robert's Rules of Order, it's kind of a minutes, reports of officers, boards, and standing committees, special orders, unfinished business, new business, and then go to the order, announcements and adjourn is typically how, Roberts lays it out. But I guess I'm thinking that, especially if we look at changing time, that maybe we move things like the principal's report, the director's report, more toward, and any committee updates towards the beginning of the meeting, and those types of things, and then we move into unfinished business and new business, and then discussion at the end, and then adjourn from there. And that might, if we end up moving the meeting times back, that would be better for the principals and the school employees to be able to show up and talk at the beginning of the meeting. And then public comment has to be in there somewhere too, so at the beginning.
I was just gonna remind you, state law requires you to have some period of public comment.
Yeah, yeah.
And this board gets to determine where that is on the agenda, and the conditions under which it's offered. For instance, Jefferson County says that if you're going to have a public comment period, it has to be something related to something on the agenda.
Yes.
It's not open mic time, but it has to be related to something on the agenda. But you get to decide that. That's something the board gets to decide.
Yeah.
Where it is on the agenda and what's available to be covered at that time.
Yeah, our current policy is it has to be 5 days before, and it has to be related to an agenda item. Or if you want it on the agenda, it's gotta be 5 days before submit. Otherwise, if you show up to sign up, it's gotta be an agenda item, so.
Williamson County has a policy on public comment time that says they allot 30 minutes. And if you have 5 people show up and want to comment, then they've got a maximum of 5 minutes for each of those people. But if you've got 45 people who want to talk in that 30 minutes, then they allot the time. You've got this much time, but we have 30 minutes of public comment, and it's about anything anybody wants to talk about, not necessarily kept to what's on the agenda. So there are lots of options there for the board
Yeah.
to choose.
Yeah, I think ours is by policy, so.
Yeah.
Policy in there, so. yeah, we definitely have that, and we usually do that at the beginning of the meeting. I know some people have that at the end, but I think it's fine at the beginning, you know, as far as I'm concerned.
That's interesting, so you're saying Williamson County has a 30-minute public comment period. Do
Yeah.
they have to sign up and get approval by the board? or
They sign up, just before before the board meeting. There's
Uh-huh.
the podium there with a piece of paper on it.
And we do that, but the
And-
board has to approve that they can speak in our policy, so they don't.
They don't do that. That's,
So, those, okay.
again, that's,
And nobody knows what they're gonna be speaking about.
that's correct. It's stumped the board time sometimes, but it can happen. And we've had some times where the chairs had to call somebody down for the comments they were making. For example, they're talking about a fight at school, mentioning students' names, and we just said we can't do that. But they put the sign-up sheet on the podium. The secretary to the board goes and gets it 5 minutes before the board convenes, and it's limited then. You must sign up by, the meeting starts at 7, you must sign up by 6:55.
It's generally pretty close to the way it works. I mean,
Yeah.
we're a small board, so right up to meeting time, we usually look at signups for
Sure.
that. But it's gotta be an agenda item if they're signing up before the meeting. So otherwise, it's 5 days before by policy.
This is one of these things that,
And it has
the
to be
policy's
approved,
important, and, but there's literally no way to do this wrong, unless you just leave something like that off the agenda. Mr. Chair and members of the board, every now and then, if you have matters in litigation, I will come to you and ask you to put things on the agenda, and will advise you where to put things on the agenda, because, if we're settling, for instance, a special ed lawsuit, we don't want a lot of discussion about that in a public board meeting. Those are matters of utmost confidentiality, and I just get approval to settle the lawsuit, but I would tell you in the executive session where the terms of the settlement, and then you just vote to settle. You vote, give me or the immediate authority to settle in that case. I would actually advise you where to put that on the agenda, so that we don't have a lot of discussion about very confidential matters.
We've been there and done that.
Yes, yes, you have, unfortunately.
They haven't had the good fortune. I get it. So do you have a suggestion, any suggestions or recommendations
On the agenda,
on format or what? Okay.
I've thought about it, and it's all over the board.
Yeah.
With other counties and whatever, it's just all over the board. I just want to toss that out to our board members to get your input and ideas, thoughts.
Okay. Well, let's come back to that. Mr. Hansard, want to talk about meeting? Oh, wait a minute.
May I speak about that also for a moment? Go ahead.
No, go ahead, Mr. Cordell.
Well, Mr. Hansard's gonna,
Okay.
speaking, Mr. Hansard's already,
Go ahead.
Thank you, Mr. Chairman. I was, one of the things that, has come up to me even before I became a board member through different people, community, is the time of not being able to come to a school board meeting, because it being so early in the afternoon at 4:30. A lot of places don't get off till 5, and even if they, were to get off, they wouldn't have very much time to get here. Proposed, to a lot of people and say, hey, look, if we moved it up an hour, would that help a lot? Not, and that would, at least that would. We want to obviously we want to keep the teachers in mind about, not being able to come here and it not being so late. I know the, Coffee County Commissioners, they don't meet till 6. They have, mentioned that to me, well, hey, look, County Commission don't meet till 6 o'clock, so why are y'all meeting at 4:30? I couldn't answer that, but we can now, and that's the reason I was wanting to bring that up to y'all and see what your recommendations are, what your thoughts were, and see what y'all thought, about. But I personally, I think would be a better time for everybody to move it up to at least 5:30.
okay. Well,
I agree with that time frame on 5:30. I thought about that too, and we don't make it harder for our teachers or whatever,
Absolutely.
but I'm just concerned that a lot of parents may not come because they're at work or whatever, they can't get here.
Yes, sir.
and we need to get input, feedback from our parents, so they can feel a part of this team and part of this process. And I was gonna suggest 5:30 also. Thanks, Scott. I concur with that.
You know, a lot of people say, well, you know, the parents ain't gonna come anyway. Well, how do we know? How do we know they're not gonna come if they ain't ever been able to be here? You know.
That's, go ahead.
I mean, if they don't, by the time they go, if they have an urgent matter or something that they wanna bring up to the board, you know, don't wanna have something every month, obviously. May not even once a year, but we wanna give them that opportunity to be here and give them time to be here without, you know, having to take off work or leave early or take PTO time or whatever to get here.
I know in, looking at the agendas from Manchester, they start at 5 apparently. And then Murray County starts at 6, and I saw somewhere one county starts at 7. But, and you're right, our county, we've always been at 6 o'clock on part of our commission meeting and encouraging the public to be there. So I suggest 5:30. And I did have one, teacher in a school a week or so other day, indicate that this person didn't know that many parents would come. But we don't know that. But we've got to make that option in my opinion,
Exactly.
make that option available to them to work into their schedules, so they can come and put things on the table that is important to them and the future of our next generation.
Yes, sir. And that's kind of what I've gathered too, is, you know, well, if not every, how long have we done this at 4:30? How many years?
Changing the meeting time has come up in the past too, and has not, we haven't changed it, but it has come up before, so. Anybody else have any thoughts on changing the meeting time?
I think it's something we're gonna have to do, because the stakeholder involvement is very low. And that may be a reason, I don't know, but you know, and I'm not the only one on this board, and I'm not speaking for everybody, but it's hard for me to get here at 4:30 in the afternoon, a lot of time. With my work, it's super hard, but I get it, I understand with everybody. I mean, the school staff that have to attend, they're staying after, they're sitting here waiting. You know, we gotta find a balance there, and I think it is definitely worth something for a agenda item on a future meeting, and have some good discussion and hear a little bit of both sides, and try to come up with a good number there and a happy medium.
Right. Well, if we change the agenda, I don't think that has to be approved, but changing the time would be at a board meeting.
It was actually a motion made to accept the dates of the meetings and the times that they start, so
For the
I would think it still needs to go back before a board
Right.
and a vote to change it.
It would have to be changed in the board, yeah. But I mean, as far as the actual order of the agenda and stuff, that wouldn't have to be
No,
approved by the board.
no, but time,
The time would be.
yeah, that's what I was.
Come anytime. What about y'all?
Well, this is my concern. I understand the parent involvement, that that's important. I also understand the teacher involvement is important. So we have teachers who are hanging here sometimes several hours past the time they get out of school. And my feeling is if we've got parents who truly want to be heard, then they'll take off work a half hour early in order to be heard. So honestly, I'm leaning towards 5 rather than 5:30. Just for both groups, trying to be fair to both groups.
I agree, that's a good spot.
Excuse me,
I agree with that, that's a good in the middle spot.
5 o'clock? Other
I can
opinion?
remember when we had them at 7.
Yeah, my biggest thing is,
And
is-
nobody was concerned that I was teaching or whatever. We just
Right.
thought of it, is that the time, the point in time. Of course, the meetings didn't run that long.
right. We could do
But
like
I'm
Tullahoma
good
and
with
have two a month.
Wait a minute, what, free to finish?
I'm good with anything.
Okay,
I'm sorry.
So, Mr. Chair, would you like this to be an item on the October board meeting agenda?
I think so, but we kind of needed to get a consensus on time. Would 5 o'clock work? I mean, that would be.
Just making decisions right now, though.
Yeah, that would be part of the motion,
It's not,
Let it be a part of the motion.
but I think
Just
that
an
would be,
agenda item is meeting
yeah.
time.
And listen, all of us need to realize, this is not a board meeting,
for
this
certain.
is open discussion, so
No
don't
decisions are
be
made.
silent.
Yeah, speak up.
I
yeah,
mean, we're not, it's not a board meeting.
yeah, we're not
This is
making any.
supposed to be a retreat.
Yeah. Five might be a good start in the right direction, just to see for a period of time and see what parents say.
Okay,
5 would be fine.
so yeah, that would be part of the motion, change the time and specify a time during the motion. So yes, that would be an agenda. Also, if we do that, then we can certainly move the principals first.
Yes.
You know, or early on in the meeting, so they don't have to, I mean, right now, they're staying here sometimes till like 7:30, and if we move them up,
Yes.
I think that would take some of that pressure
More.
off too, so. So, okay,
I agree with the idea about letting the principals and staff go first.
We probably need to discuss it with the three that come
Yeah.
every meeting.
Yeah,
They're very loyal.
yeah, they are.
Mr. Chair, at your discretion, I will say that if you wanted to give Mr. Cagle 45 minutes to talk, we have 35 minutes until the scheduled lunch. So that's, depends, maybe you intended for him to talk after lunch, I don't know, I'm just giving you the warning.
yeah, we were gonna kinda see, but we may want to, yes, to, change the agenda order, and I don't think there's any problem doing that unless Mr. Keg will go now and then break the
I'm-
lunch.
My time is your time, and you'll not hear a lawyer that won't say that.
Well, why don't we do that? I mean, yeah,
I'm amenable to a change if there are other things you need to discuss. I think this discussion's healthy, so
well, some of these next ones might take a little longer, so
Okay.
let's, do the time before lunch, and I think lunch was planned kind of as a natural break somewhere.
Okay, thank you, Mr. Chairman, members of the board, and other folks who are in the room, members of the staff who are here. My name's Chuck Cagle. I am with the law firm Lewis Thomason in Nashville, and for the past 10 or 15 years, I've served as counsel to this board, and it's been an experience. Representing school boards is always an experience, because you can't tell from one minute to the next what Dr. Lawson's going to have when he calls me on the phone, and it literally can be an emergency, or it can be just a matter of just a regular inquiry. Sometimes the house is on fire, and sometimes there's blood on the floor, and we just have to deal with it. So that's what we do. The practice of education law is the best general practice of law in the world. I have literally handled cases in the alphabet ranging from A to Z, from attendance to zoning. My most interesting case probably was a murder case where a parent murdered his children, and the school board got charged with it. Second only to that was with the school board was charged an accessory to allowing the children to leave. The second most interesting case I had was in front of the Federal Communications Commission in Washington, D.C., where we went and argued the E-rate funds case. In the middle of that, I've handled banking cases. You have to have your funds capitalized, as a school district out in West Tennessee found when we found that a bank was going to close, and they had $900,000 in that bank that the assets were not capitalized. And we had to make sure that the receiving bank was going to capitalize those assets, or I was about to instruct the school superintendent to write a check for $900,000 and go cash it. So that's interesting. We deal with property issues, we deal with special ed issues, civil rights issues, constitutional issues of all sorts, and the list just goes on, and sometimes the interesting ones get to be about yellow conveyances we call school buses, and everything that can happen on a school bus. Social media is one of the things we deal with every day, and today, as you might imagine, we're dealing with social media and threats. As I sit here, our clients have about 14 or 15 students who are locked up. We represent 70 school boards, and we have about 14 or 15 students who are in lockup because of threats that they've made in the past 5 days. So that's becoming a really big issue. As I said, we represent about 70 boards of education in the state. I represent also 5 private colleges and a private medical school. So I get to see education literally from disabled preschool children who are about to enter 3rd grade all the way to postdoctoral work. Because medical school I represent is a single degree granting institution that grants only a doctoral degree in nurse anesthesia practice. So it really is kind of an interesting practice. As I said, we cover just about everything. I've had superintendents call me and say, I bet you haven't had this question before, and sometimes I haven't. And that's always a good day. It's always a good day when I haven't had that question before. I practice everything but criminal law. People say the way I practice law is criminal, so that makes up for it. But it really is a good practice. What's the role of a school board lawyer to the school board? For whom do I work? I am employed by the Board of Education. I work for the school board. I work with the staff. I work with the staff of the school system, and if as need arises, when issues come up, I will convene, or I'll ask the chairman to convene a meeting of the board via Zoom most of the time, or we can come and meet in person if that's necessary. But if the need arises, then I'll ask the chairman to call the board together that we have a problem that I need authority to act on behalf of the board. I have no unilateral authority except to act within the law. If Dr. Lawson and the staff here call me, whether it's a special ed director, whether it's the director of schools, whether it's the director of finance, if they call me and they ask me a question, the question that I give them, I'm acting as the Board of Education in that question, when I answer that question, because I have to say, first of all, what does the law say? What does your policy say? What does the board policy say? I have no ability, unilateral ability, nor does any school board lawyer have any ability to waive policy. So once I've gotten the facts, I'm going to say, well, here's the law, here's what's the board policy, what's the board procedure. Sometimes I may ask, have we handled this question before, and how have we handled it? Not that anything we do establishes a precedent, but I still think that some element of consistency is a good thing. So how have we handled this before? We faced this particular problem before. And every now and then I just look at the staff and say, you can't do that. I mean, that's a good portion of what I do. You just can't do that. And if not that this staff would do that, but if any staff wants to argue about it, I say, I tell you what, you can't do that, and I'm about to put it in writing to you. And I'm also going to copy the board members. If you can't do that. Occasionally we get a call from members of the staff, and as many of you have heard me speak before, they say, this is what I'm going to do. And my favorite phrase there is, let me tell you what's about to happen to you. Because you haven't looked at your board policy, you haven't considered, aspects of the law, you haven't considered, the fact that this child may be a special ed student rather than a special ed student, or members of the staff, you haven't considered the fact that you just don't have the authority to do that under the statute. Tennessee is a Dillon rule state, and any public official has only the power that's given to them in the statutes. And if there's any doubt about that at all, they don't have that power. So, for instance, I get superintendents who call me all the time saying, I'm going to suspend a student. I go, no, you're not. A superintendent of schools has no authority to suspend a student in Tennessee. Only school principals do. So we need to get the principal on the phone so that I can advise the principal if this is a true suspension situation. But the superintendent's name can't appear on that suspension letter. Only a principal's name can appear on it. Conversely, I get principals who call me and say, I'm going to non-renew an employee, and I go, no, you're not. That power lies with the office of the director of school. You can recommend non-renewal for an employee, either a classified employee or termination for a classified employee, or non-renewal for a teacher. But that power lies only with the director's office, and that is a non-delegable duty of the office of the director of schools to non-renew employees. So it goes both ways. But every time I give an answer, the person to whom I'm ultimately responsible is this board. It's not to Dr. Lawson or any of the staff, it's to this board. about a decision that I have made or advice that I've given as a result of the situation that has arisen up there. So that's the role every school board lawyer plays. School board lawyers are kind of like parliamentarians, as I said a minute ago. They need to be kind of invisible most of the time. But when they need to be visible, then they need to make sure that they give adequate advice upon which their client can rely. That's not different from any other practice out there. Our firm has lawyers who represent Ford Motor Company. We have lawyers who represent construction companies. We have lawyers who represent architects, lawyers who represent people who, insurance companies and trip and fall cases and things like that. We have a very diverse practice among the three offices of our firm, but all of us work for clients, and we give advice upon which the advice upon which we trust our clients can rely. So that's my job to you, and occasionally I have to just look up and say, you can't do that. You just can't do that. Cases that I think are very important, that when you will hear me speak up, if I'm attending a board meeting or if I'm asked about a certain situation, are conflicts of interest among board members. 49.2.202 states that a board member has to declare a conflict anytime you're voting on an item of business before the board and you have a relative who works for the board who's affected by what you're about to vote on. You must declare a conflict of interest there. Doesn't mean you can't vote. 49.2.202 says you must only make the conflict, you must only declare the conflict. So if, for example, any of you have daughters or sons or spouses who work for the school system, you're about to vote on a teacher salary increase, you say, I have what appears to be a conflict of interest, but I declare that my vote is in the best interest of the school system. That's all you have to do, and you can go ahead and cast your vote. So I go to a lot of school board meetings where I raise my hand and go, is there anybody here who needs to declare a conflict of interest here? The second place that I will intervene on an irregular basis, and let me say it is irregular, is I read the minutes of the board. I actually spend my time reading some minutes, and the law in Tennessee is a public entity, be it the county commission, be it the school board, be it a beer board, whatever it is, those entities only speak through their minutes. It's not that recording that you make, the minutes of the board. The B&B Entertainment case out of Wilson County is the case that the Supreme Court of Tennessee says the minutes of the board is the official record of the actions of the board. So I may call the superintendent or the board secretary and go, I know this was discussed, but I think you need to include some language about this at the board meeting so that it's clarified what happened in this action. And I want to make sure that my client's protected so that if it ever becomes an issue and somebody has your copy of your minutes and they say, well, you say you did this, but where's that in the minutes? Where is that in the minutes? Then we need to make sure that the minutes are clear. The minutes are not verbatim transcripts of what went on at the meeting. I want to say that. It's not a verbatim transcript. I was saddled 4 or 5 years ago with, I was hired by an out-of-state university to try to bring them into the 20th century. Actually, they were operating in an arcane way in just about every method. And one of the things they asked me to do was read 20 years of their minutes. I wish they had put me in prison rather than ask me to do that. Because I started reading their minutes, and if a trustee of this university was absent because he had a car wreck, that was notated in the minutes. If a trustee had been caught doing something for which that trustee had been, tapped by law enforcement, for example, getting a DUI, that was in the minutes. And lots of things were in the minutes, and I said, folks, we need to fix these minutes so that it reflects the actions of the board, the discussions and the actions of the board. Was there a point of discussion that's noteworthy about putting in the minutes? And then who made the motion, who seconded it, what was the action of the board? I took 20 years of minutes, which was about this thick, and I turned them into a stack about this thick after I rewrote all their minutes for 20 years. And they adopted them. as they were allowed to do under the law of that state. They readopted the minutes of the board, reapproved them, and posted them. I said, now that's an example of what you want. Again, the minutes are not a verbatim transcript. We don't need to know everything that was said. We don't need to know how everybody felt about everything, but we do need an adequate description of the item on the agenda, what it was about. Was a motion made and seconded to approve it? Were there amendments to it? And how were the amendments adopted? And then we need a final vote on the issue itself.
How does, we do obviously recordings, video
Yes.
recordings. How does that relate to minutes legally?
It relates to them in the fact that they should be in harmony with each other. I mean, the recording should not, your recording should not contradict what's actually in the minutes. It's just that the minutes don't have to include every conversation or every bit of every conversation or even every question that was asked during the meeting itself. But oftentimes when we get requests for either public documents or requests for discovery, if there's a lawsuit, they'll ask for both recordings and the minutes themselves. I'll just say this, taking minutes of a meeting is an art. There's an art to that, and TSBA does a lot of training on that. I don't know if anybody's been to the training or not, but the TSBA does a training on that, and it's pretty much an art form to make sure you get what's important and leave out what's not important as far as the minutes go. But we have state Supreme Court authority that says that the only way this board actually speaks is through its minutes. It's through its minutes, and that applies to county commissions. And just the B&B case was a beer board case out of Wilson County. And there's a case out of Jackson-Madison County that deals with items similar to that. But I want to make sure that you're not putting things in there that are not required, as well as putting things in there that are required. We want to make sure that the minutes are an accurate reflection of what went on here. The other thing I do is I look at your agenda. We now have a law in Tennessee that I've asked my clients to comply with, that even though the sponsor says it only applies to county commissions, I think it's advisable for school boards as well, that I've asked all my clients to abide by it, and that is that you post the meeting agenda 24 hours in advance of the meeting so that there's not an accusation of a public meetings violation. Now, does that mean that if there's a true emergency that you can't come in and amend that agenda? No, that's not what it means at all. And I can think of dozens of times where we've had everything from electrical fires to student accidents where we've had to come in and amend an agenda at the last minute, put on an item because the school board was meeting that night or the next night. But under the normal course and scope of business, and under your policy, the chair and the superintendent who generally put the agenda together, they need to know what we need to discuss. And that's where the annual agenda comes into effect. I had a school board this year who missed a grant application because the deadline wasn't on their annual agenda. That annual agenda means something. It can cost you money. I mean, it's literally, if you miss a grant application deadline, you've lost that money. So any deadlines that you have that are significant like that ought to be on an annual agenda for the board. I'll occasionally take a look at the agenda and look at them, but I think posting that agenda saves any accusation that the school board violated the Open Meetings Act by taking up items that were not on the agenda for convenience. And that's what we want to avoid. Oh, we left this off, and we'd really like to have this approved tonight. Well, can that wait till another meeting? And if it can't, then you need to say that. This is an emergency. This needs to get done. Or can it? Can we put this off for another month and have no harm from it? And we're beginning to see a lot of complaints like that about where boards of various types will just amend the agenda at will during the meeting and take up issues that were never on the published agenda. And that the Office of Open Records Council in Nashville has ruled that that's a violation of the Open Meetings Act. So just be aware of that. But again, it takes putting together the minutes is an art. Putting together an agenda and thinking of everything that needs to be on that agenda is also an art form, and it's one that's not done casually. You really have to put some thought into it and be ready to amend the agenda and justify it if a verifiable emergency occurs that needs to be taken up. Any question about that? The other thing that school board members, the school board attorneys have to do, and it's kind of sometimes an unfortunate thing, but it's one that we just do it. We just have to do it, and you just, I've been doing this 35 years, and I don't blush anymore. You know, I don't breathe too hard anymore. I just sort of, you know, take my cues and say, you need to tell somebody what they can do and what they can't do. Sometimes when I'm joking around with people, I say my job is to keep about 70 school superintendents. My regular day job is keeping about 70 school superintendents and 5 university presidents, and about 600 members of boards of trustees or boards of education out of jail, some of whom ought to go. You know, we have some board members out there who are just going to violate the rules. And it's the job of the school board attorney also to say, I think you ought to reconsider what you're about to do. Now, there's a way to say that. I have a colleague who just calls up his clients and says, you can't do that. Not my job. Not my job. It's my job to call you and say, I think you ought to reconsider. Or my famous phrase, let me tell you what's about to happen to you. Because if you take certain actions, then you could be personally responsible. We've got jurisprudence all the way back to 1895 in Tennessee, a case called Fine versus Stewart, where a school board member actually gave permission or authorized the purchase of school supplies in the amount of $35. Now, put this in perspective. This is 1895, so $35 was a pile of money back then. And he authorized this single school board member authorized the purchase of the school supplies. The contract for the supplies, or the approval of supplies, came to the Washington County School Board in Upper East Tennessee. The Washington County School Board turned them down. They rejected it. And the vendor sued the school board. And the Tennessee Court of Chancery Appeals ruled in that case that no individual board member has any authority to act unless you're gathered in an official meeting. You have no individual authority. So every now and then I'm forced to call a school board member, not that I've ever had to do that here, and I'll tell you I haven't had to do it here, but I have had to do it. I'll just call somebody and say, we probably need to get you in contact with business director of the school system or the superintendent or something, rather than you jumping out in front of this and making it look like you actually have this authority. A real example of that was about 5 or 6 years ago, I had a member of a school board go onto a construction site of a school, look at a contractor who was there, a subcontractor actually, and say, you're not going to locate this electrical service line here, you're going to put it over here. The subcontractor effectuated a change order. That change order cost $6,000. It came to the school board, and the school board said, we're not paying it. Whereupon they looked to the school board member who went on the construction site and said, you're going to pay for it. Now, as you might imagine, there's a hole in the ceiling above where he sat that night, because he hit the roof. He said, well, I do this and I know what I'm talking about. It doesn't matter. You don't have the authority to do that. You don't have the authority to do that. So respect your position and respect the other, and I would ask that you respect the other members of the board by not making unilateral decisions, because that may be a decision for which you become personally liable. And every now and then I have to call and say, there's a better way to do this. Can I help you? You know, as I often say, I'm from the government. I'm here to help you. So let's think about a better way to do this. If that line really needs to be moved, then let's talk about how we move the service line into the school. And you know, most of the time in the AIA contracts I read, and even for this district, we have an appointed representative of the school system there. It may be the director of schools, it may be your maintenance supervisor, it may be a contractor who fulfills that role. But we have an appointed school representative, and we tell contractors, don't take any direction except from that person, because that person has been approved by the board to serve as the school's representative on this construction project. So there's a space for that in an AIA contract, and I always call up the school board or the chair or the director of schools and say, we need to fill this in. Somebody needs to be designated as the authorized representative of the school for this construction project. So that's the way sometimes by contract, we can avoid that, but other times, we just need to be aware that of what the limitations on our responsibilities are. 49.2203 is the section of the law that deals with the powers and duties of the school board. 49.2203, I'm not going to read it to you because we will be asleep we'll take our nap before lunch if I try that. But let me just say that there's some real important things in there, and these are all non-delegable duties. You can't assign this to the director of schools. I'm going to talk about something very different in a minute with regard to the director of schools. But the school board has to produce a policy pamphlet. And the law says it has to be available both in electronic and in a hard copy format in each school library. So we have electronic, and now we're trying to get that law changed to just make sure that electronic format satisfies all publications. It says that you have to produce an annual budget, and that budget has to be balanced. It has to be balanced. And I know that Gary Cordell will correct me if I say something wrong, but the county commission has no unilateral authority to deal with any line item in that budget. If they disagree with something, they have to send it back to you. You have final control over your budget. And no finance act, either the 57 Act, the 81 Act, 93 Act, or any private act that's adopted can give the county commission the authority to deal with the school board's budget. It's also your responsibility to make sure funds are spent responsibly. Can you ask questions about expenditures? I would hope that you do. I would hope that you do. But those funds have to be spent responsibly according to the line items in which they're appropriated. And if we need transfers in that budget, there are times when the school board can transfer funds between lines in a major category. But if you go among categories, then that's going to require school board and county commission approval. The other thing that you do is you set personnel policies. And then that's very, very important for somebody like me who's representing you. Because I'm going to take a look at your policy and see what it says. The next thing is not only personnel policies, but student policies. A policy, the one that I rely on most, is a policy on progressive discipline. Unless it's a zero tolerance offense, people, hearing officers and others, and school boards and lots of other folks like for us not to lower the hammer on a student the first time something happens, except if that student carries gun school or something like that. Then we got a problem. We got federal law that interferes, that intervenes there, and says how we have to act. But I'm going to take a look at your policy manual on a fairly regular basis, and as policy changes come up, and as most of the time, Dr. Lawson or his office will send me a policy change if they have a question about it or if requested by the board, and I'll weigh on it, and say, well, I think this could be clarified this way. Either the policy's fine, I think it ought to be clarified this way, or amended according to the law. And trust me, policy revisions and keeping that policy manual current is an absolute requirement for this board. Unfortunately, the legislature meets every year, and they change the laws every year, and your policies have to conform to those changes in the law. Now, with regard to, you all get your policies from TSBA?
Yes.
Read those policies and make sure that they conform to the way that you want the policy to read. That is a recommended policy. That is not an absolute policy. So those policies can be amended to suit your individual circumstance here. Read those policies. Read those policies and make sure that they conform to what Coffee County needs and not what everybody across the state's adopted. And that is certainly a privilege that you have as a result of that membership. I think they do a wonderful job with their policy service, but every now and then there are peculiarities in the operation that you've just done over time. You have peculiarities here in the way that you've done things. Amend your policy to make sure it does what needs to be done. The next thing is any question about that? The policy manuals, budgets, there's all kinds of construction bidding. I argued a case many years ago in front of the State Court of Appeals. I'll never forget this case. I had to argue it on Monday morning after the Titans played in the Super Bowl. So I didn't get to watch the Super Bowl 1 minute. the year they played in it, but because the next morning at 9 o'clock, I was in front of the State Court of Appeals. Only school boards can build school buildings. So make sure you hire good contractors, architects, and engineers. Make sure you effectuate good contracts with all those folks, and make sure that they're working for you. The school architect is the same as the school board lawyer. That architect works for you. That contractor works for you. And let's not get the cart way in front of the horse here and let them say, well, because of my superior knowledge on something, that I'm going to do what I need to do. No, the architect draws the plans. The architect sees that the plans are drawn, are conformed to by the contractors. Everybody works for the school board. Everybody works for the school board. That doesn't need to be turned around. If it does, you can be in a real mess with the building that you're going to be stuck using for the next 35 or 40 years. So just make sure that you're getting what you need out of it. There's requirements in there about meetings, about publishing meetings. There are requirements about bidding for HVAC systems. As of 1994, there is a requirement that a school board in Tennessee appoint a director of schools under a written contract of employment not to exceed 4 years. For history purposes, Tennessee was not the first to do that. We were among the last. We were among the last. When Tennessee passed its law in 1994, there were exactly 110 elected superintendents in the nation, and 70 of those were in Tennessee. Every other state, every other place had gone to appointed school superintendents. So, that is a power, and that is a heavy power that the school that the board has been given, is the election, is the nomination and the contracting for a director of schools. And then you set the employment contract for that person. You get that contract approved by a board in a regular meeting, but that is your authority. And I would urge you not to do anything to interfere with that. Not to do anything. We have had the cleaner operation of schools. I started practicing law when we had elected school superintendents. And I represented the district where the school superintendent disagreed with the school board about an issue, and not Dr. Lawson, don't get me wrong, but this superintendent rode a motorcycle. He disagreed with the board about an issue, and for his last 6 months in office, he would come in one day a month and sign paychecks, and he'd jump on his motorcycle and leave. He was an elected official. We couldn't force him to do a thing. And he decided he's not going to enforce a policy. What's the school board going to do about it if that person is an elected superintendent? So we have a very, very workable system in the relationship and the employer-employee relationship between the director of schools and a school board, and a good contract of employment covers most of the terms of it. But as I have to remind the director of schools, you like me we're saddled with the policy manual. We're saddled with the annual agenda. We need to make sure that things get done, get put on the agenda. We're saddled with a budget that's been approved by both the county commission and the state of Tennessee. And we're saddled by a whole bunch of federal laws out there, federal acts and federal laws that apply to school systems. And that's a speech for another time. I'll assure you that speech is an hour long, and I've got a list of about 75 laws and regulations and constitutional provisions that you have to abide by. But every now and then I go, when the director calls, I'll just say, no, there's a case that says you can't do that. And here's the case that says you can't do that. Finally, in 49.2301 is the powers and duties of the director of schools. And these are also, for the most part, non-delegable duties, although the legislature passed an act that says some functional duties of the director of schools, he or whoever the director is can delegate some of those duties to other folks within the administration of the school. What has to happen for the director to do that, to have that delegation power, is the board has to pass a policy that says the director of schools can delegate this list of duties to somebody else. Well, what would that be? Well, maybe appearing in front of the county commission for quarterly updates on the budget situation. I don't know if your trustee still does it. He's next door. He's not far away. But there's a quarterly balancing of all accounts of the school. Well, the director may designate the school system finance director to go to that meeting rather than the director of school. That would be an example of it. But the director can't, for example, delegate the non-renewal of teachers or the termination of classified employees to somebody else. That's statutory. That's something that could not be delegated. Attending certain meetings, for example, the director of schools could do that. Other than that, we do have a pretty significant case, State XRL Thompson versus Walker, Shipper, and others, out of Wilson County that says that the words in the statute in this case mean something. 492301B1 says it's the duty of the Board of Education to assign to its director the following duties. These are duties that are these are day-to-day operational duties that are removed from the school board and placed in the office of the director of schools. And that list goes on and on. Basically, the school superintendent or the director of schools operates the school system on a day-to-day basis. And that's general jurisdiction over the schools and the operation. The Board of Education has specific jurisdiction over all the schools in the district. But you have to hire somebody a director of schools who actually does those things, operates the schools, makes decisions about personnel, makes decisions about employment issues, makes decisions sometimes about special education issues and others. That person actually operates the school system on a day-to-day basis. And there's three or four pages of what goes on. But in the Walker case, Thompson versus Walker, Shipper, and others, in that case, the State Court of Appeals said that language means something. That language means something. So there is a separation of authority between the Office of the Director of Schools and the school board, so that the school board has they make the big decisions. They make the big decisions. The confirmation about whether Dr. Lawson is going to uphold a zero tolerance offense is his. Under this section of law and under 49.63401. That falls to the Office of the Director of Schools, making the final decision on whether or not to amend a zero tolerance offense, the penalty for a zero tolerance offense. So the statutes pretty much set out those to say it's day-to-day operation and then general operation of the school system. And you must assign the following duties, all these duties to the board, to the director of schools. Again, the school board lawyer is also, as we work with the staff, I don't make it a habit and never have of saying, well, the special ed director calls me today, and they have a particular problem with a special education child. The advice I give, I don't generally send on to the Board of Education, and there's an exception to that, unless it involves school system expenditures and significant school system expenditures. Then I don't have the authority to spend your money. I don't have that authority. Somebody has to be involved in that IEP team meeting that has the ability to bind the school system. But I don't have the authority to spend your money. So that decision, I'm going to advise on that decision, but that decision has to be made by the director of schools or by the director of special education or by somebody with that authority. But those kind of everyday routine decisions like that, I generally don't correspond with the board on. I generally will correspond with you more than maybe you want, because I get nervous about things that you don't know. And I don't want the last thing that I like to hear from any board member is, well, why didn't you contact me about that? That is a board issue. And sometimes I'll say, yes, we should have done that. We shouldn't have done that. If in fact correspondence has been skipped. But on the regular routine day-to-day issues where the special ed director, the finance director, the school food service director, transportation director calls me and says, we've had a car wreck, and if there's been a bus wreck, then I'm going to contact the director of schools and say, get on the horn now with the school board. They don't need to hear about this on the news tonight. If there's been a gun at school, get on the horn and contact the school board members and tell them that we've located the gun at a certain school. They don't need to hear about that through social media. Those kind of issues, I advise the school director on a pretty regular basis, tell the school board about it. The fact that, as I mentioned a while ago, that the school missed the deadline for a grant because the supervisor just forgot about it and it wasn't on the annual calendar. The first question the director asked me was, should we inform the school board about this? I said, if you don't, I'm going to recommend that you be fired. Yes, you do that. You do that right now and just let them know that if we intend to continue this particular program, it's going to have to be funded out of local dollars. So there are two decisions to make. Do we continue the program and do we appropriate local dollars? Then if we do, where do we get the money from local dollars, from undesignated fund balance, for example, to pay for that program? Yes, you absolutely inform the school board that we missed that deadline. That's very important. That's not the day-to-day operation of schools. You're not making a decision about it. You will be asked to make decisions about it, but that is keeping you informed. My job is one of my jobs is to advise the school director that the board needs to know about this right now, and do that, either do that or assign a member of the staff to get in touch with the school board. However, whichever way works best for you, text message, email, smoke signals, I don't care. Let's get in touch with the school board and let them know about it. And number two, to also assist in some of those routine day-to-day decisions for which you really don't have, there's no really legislative or administrative authority to let this out. There's just no need to let this happen. Routine suspensions from school, for example. If I get called about a routine suspension from school, I'm probably not going to notify or advise that the board be notified about that. If I get a letter from a lawyer that says I'm going to sue you, yeah, I'm going to send that to you. You're going to hear about it. You're going to hear about it. Even if it involves a suspension from school. Or if I see that one is about to be appealed to the board, then it's my job to notify you about a suspension that's going to be appealed to the board and what the circumstances are of that suspension. But that's it. Other than that, we just try to be prepared to deal with whatever happens. As I have told some of you who've heard me, and Frida, who's known me forever today. I tell folks that I can walk in with a great agenda and work I'm going to get done, and 2 phone calls later, it's burned. It is just burned because of things that happen. And we just have to, we go prepared to try to answer our clients' needs. The practice of law is the practice of law in real time. If a student gets in trouble, it happened today. If bus wrecks, it happened today. If a student brings a gun to school, it happened today. If a teacher abuses a student, it happened today. All of the rest of the folks outside the education law practice group in our firm deal with stuff that happened a year ago. And if a car wreck happened, they may wait till the statute of limitation is almost run, 365 days, until they actually file a lawsuit. So when Randy Bibb, with whom I practice law, does something for Ford Motor Company, he's dealing with a situation that may have happened as much as 2 years ago. And he's having to reconstruct facts. When you call, or when the superintendent calls, it's happening right now. And you need an answer, and you need a way to get in touch with him. And I hope that, I hope that we don't let the board down, who is our client, I hope we don't let the board down in communicating with you at all times, but just understand that sometimes it's tedious. And we can inform you about it, and then we're going to have to say, we'll tell you what happened in a few minutes. As I'm so fond of telling superintendents, I've got the next 3 hours figured out, and after that, I'll figure out the next 3 hours. And after that, I'll figure out the next 3 hours, because that's just the way school is, folks. It can change in 3 hours, whether it be weather or any other circumstance. Mr. Chairman, that's what I came prepared to talk about. I can fill up a lot more time if you need to.
I do think we have lunch, but does anybody have any questions for Mr. King?
I just got one, and I wanted to clarify this for us. We have been in an email thread as school board members, and all of us were on that same email thread where we could communicate. The director communicated with us via that email thread.
Yes.
And we were told that we were possibly violating the Sunshine Law. How is the way of communicating?
I don't think it's a violation of the Sunshine Law to have the thread. I think we should all remember that thread is is public record, and anybody can ask to see it at any time. If you're using the thread to make decisions, to deliberate toward a decision or make a decision, then yes, that would be a violation of the open meetings law, because it'd be deliberation outside. But if it's just informational, if the director of schools is sending you a Friday thread or whatever that says, this is what happened in Coffee County schools this week, there's not a problem with that. It's all discoverable, so we shouldn't put anything in there that we don't want discovered. But at the same time, if we commence discussing these issues among ourselves, then that's probably going to be looked at as deliberation. And so if Frida gets the thread and she emails Tom and says, what do you think we ought to do about this? If I see that as your lawyer, I'm going to say, discuss that in open meeting.
Okay, let me give you an example. For instance, if all of us had the same email that school was being closed tomorrow, and say I said, well, I don't think that's a good idea, or just made a comment back for everybody to see my feelings or whatever, would that violate the sunshine law?
It's not a violation of the sunshine law. You haven't deliberated anything
Okay.
at that point.
That was
You've
my-
stated an opinion. But if our friend from the newspaper here were to decide that he wanted to, newspaper or radio, if he were to decide he wanted to see all those email threads, then he could see them, and we'd have to produce your comment as well.
At what level does this board have of confidentiality, if they had questions with you, their legal representation or whatsoever, as far as the level of confidentiality before it becomes public knowledge?
If there's active litigation, number one, that's covered, that's an exception. If there's active litigation, or if there's an active controversy. The case of Van Hooser versus Warren County Board of Education says that if there's an active case or controversy, the lawyer who represents a public entity can actually give his or her advice in a private setting, and that's not subject to disclosure. And the privilege belongs to the board. It doesn't belong to an individual.
Any one board member.
That's right. It belongs to the board. So it's privileged information. I find myself on a fairly irregular basis, but it happens, taking boards into executive session, particularly if we're trying to settle a special ed lawsuit, due process hearing. If we're trying to settle a lawsuit that's out there, or we're trying to stop something that's about to happen. I've gotten several of those, particularly in property issues, where a grading contractor's gone out and moved some dirt around, and suddenly I got water on everybody else's property out there, and they're threatening to sue. Well, let's see if we can't get this fixed. Give me the authority to work with the lawyer for them to get it fixed. But then I'll take the board into executive session. This is a pending controversy. Here's what the issues are. In that session, we can't make any decisions. I can only get basically a consensus of opinions from the questions and comments, but we're not allowed to vote or take any decisions. Any votes that occur by this board, please understand this, I'll say this only once, any votes that occur by this board must occur in a public session. But
I just wanted some of the new folks to understand that if they do have questions for you, and it
Yes.
could be something that could lead to a controversy or
yes,
that they do have some sort of confidentiality with you, but it includes everybody else on the board as well.
it does include everybody. As I'm so fond of saying, lawyers do have a book of ethics. It's kind of thin, but we have a book of ethics. And one of those canons in the rule book of ethics is that we maintain the confidences and secrets of our client. So if a question is asked of me, then I'm not going to talk about it anywhere, and I may even send out a confidential communication that says, I've been asked this question, this was my response. This is attorney-client privilege. If it's attorney-client privilege, it'll say that at the top, confidential attorney-client privilege communication.
And if any one board member or anybody asks for it to be confidential, whether some may think it's not confidential or not, is to be treated as such until basically proven otherwise to be open to the public, correct?
Yes, unless of course I just say this can't be confidential.
Right.
is, it can't be a confidential matter. Let me cut off this phone. Some superintendents found out that I'm sitting still.
Welcome to the party.
Yeah, but, you know,
Double bill, huh?
that's, you know, the school board attorney has to has to tell the client sometimes what you've asked me can't be confidential. And I'll just give you a real example of that. I have school board members all the time who just will call up and say, what is the law on this? What did the legislature do? Giving advice about what the law is not confidential. There's a case out of Metro Davidson County that says that. But when you ask me how to apply that law to a situation at school, that's when the confidentiality attaches. So there's some mystical, magical moments out there where things can change.
I have a question on something you brought up. Now, as I understand it, suspension, you said, is in the principal's hands?
Yes.
Okay. So when you said that it can be appealed to the board,
Under certain circumstances, yes.
okay, so does that mean at that point the board would have the decision-making on that?
Yes.
Okay. So what kind of cases does that come up?
Let me give you two cases that would go very different ways. And actually, there's a third type of case that could go way far away from this, and neither the board nor the superintendent would ever hear it in most cases. Let's say a student sends, a student gets in a fight. 49-6-3401 says the principal, an assistant principal or principal teacher has the ability to discipline a student. And that leaves out the superintendent and everybody else. However, underneath all that, there's such a thing called the disciplinary hearing authority. So the DHA meets and hears, and I don't know if Coffee County uses the DHA or not. They don't use one? Okay. But the principal can suspend the student for up to 10 days under a case called Goss versus Lopez. And there's really no right to appeal that anywhere, unless the student is disabled. Now, that gets you in trouble. There's always an exception for a disabled student. But the student gets in a fight, the student's suspended for 15 days. Then the student, if the school system does not use a DHA, the student and his or her parents have the right to appeal that to the Board of Education. The Board of Education can agree with what the principal's done without holding a hearing, but if you think that something more specific should have been done, something more harsh should have been done to that student, then the school board has to hold a hearing on that. Now, that's one of the exceptions under the statute for which a school board can actually go into executive session. To hear that because of what? Confidentiality concerns. So if the parent, it says the hearing shall be closed unless the parent requests that the hearing be open. And those are very uncomfortable, but you actually sit there and you hear a case and you make a decision on whether the principal should be upheld. That's the first decision that's made in parliamentary procedure terms, Mr. Chairman. The first decision that's made is, are we just going to uphold what the principal did? If we do that, no hearing is required. If we vote that that's not harsh enough, that we want to go 30 days, for example, then you have to hold the hearing yourself. Now, take another instance. Student brings a firearm to school. 49-6-3401G says that that's a zero tolerance offense. That comes from the Gun-Free Schools Act, and Title 20 of the United States Code says that every state that receives federal money has to have a law in place that says if a student brings a firearm to school, they're subject to a 365-day suspension. Subject to, not mandatory, but subject to. Our state has that law. It was passed in 1990, and it's been in place ever since. The appeal procedure there goes from the principal, who must assign a year's suspension, to a DHA, if you have one, that can recommend a year's suspension or some modification, not to the school board, but to the director of school. Because the law says a zero tolerance offense is appealable to the chief executive officer. Only the chief executive officer of the school district can make a decision on that on a case-by-case basis. School boards would never hear a true zero tolerance offense. Now, fighting or carrying a knife to school may be a zero tolerance offense under your policy, but it's not under the law. So we literally have to sit down and analyze what happened. If it's a firearm, it goes one way. If it's a fight, it may go another way. If it's a weapon of a different type from a firearm, it may go another way. If it's a special education student, it's going to go every way. Because we have to go through manifestation determinations and lots of other things and make sure that the child's rights under federal law are not violated. So we have to sit down and analyze, what happened, and how it happened, where the appeal is taken, and who has the right to appeal, and how many days and things like that. So that again is both statutory and policy driven, and it's one of those issues where I just say, okay, let's just sit down and map this out. Tell me what happened, and always the first question I ask is this student a special education student? Because you can tear up the regular recipe and go to Plan D at that point.
Any other questions for Mr. Cape?
I do take phone calls from school board members. I prefer that you folks have some sort of protocol for doing that, but because I just have to admit that it's not missionary work. I don't do this for free, and I don't like spending school board money unnecessarily. If there is an item that you whatever your protocol says, if it's okay for school board members to call, I'll be happy to answer the question. If you want to send those to me via email and how you want a response, I'll do whatever your policy, whatever your protocol is. But most of the time, we establish a method by getting these questions unless there's some urgency to it. Let me just say that. There's always that possibility, but unless there's some urgency to it, let's agree on a way to contact the school board lawyers. I'm not spending a bunch of your money. Get it to the executive committee, the board, they'll forward it to me, so that there's some coordination there. Again, unless there's a true emergency.
Policy would be good on that. I don't think we do.
I don't think we do, yeah.
So our liaison is actually the chairman of the school board,
I work,
or the executive committee.
yes, I work in most cases where there are questions, just questions to be answered to the school board attorney. I prefer to work through the executive committee, because I'm going to respond to everybody. I'm going to submit a response that is developed for everybody's consumption. It'll either be privileged or not, confidential or not, depending on what the question was. But rather than just having everybody with the ability to call, because I think, again, I have to be conscious about the way your money's spent.
I gotta say, starting my 5th year, this is great that you was able to make it here today,
Thank you.
and us to actually, I'm just so glad to actually got to finally meet you.
You hear my name, and it's usually preceded with a swear word, I know.
And it's, just what was discussed here, the way you've laid a lot of things out is really great for these new board members.
Yeah.
I wish I'd have had it 4 years ago.
I really like it when things work well. It's, I have a habit of, I have two statements that I live life by. The first one you've heard over and over again. Let me tell you what's about to happen to you. But the second thing is you get a reputation for bravery by letting everybody else panic first. And, I like to sit back and just say, okay, now let's deal with this. Let's analyze this and let's deal with it. Let's not panic first. Because oftentimes, if we panic first, we're wasting valuable time in helping students. So let's make sure that we protect the students and our employees well and make the decisions in a timely fashion. And I kind of like it when it flows really easy. And I try to tamp down excitement as much as I can.
All right. Let us break for lunch, and Mr. Cagle, we would be honored if you would join us for lunch.
First, Mr. Chairman, I hate to correct the chairman of the board because I understand the person for whom I work. My name is Chuck.
Okay.
Mr. Cagle died in 1974,
Okay.
so my name is Chuck.
All right, Chuck. We would be honored if you would join us for
Thank you.
lunch and some barbecue, so,
Give me about a minute.
okay?
Thank,
We can take a break and,
Chuck, thank you for being here.
Yeah.
Thank you, sir.
Blood back in their legs from there.
yeah, well,
Now it's from Charlie Brown. What's up, Chuck?
I know I need to go to the restroom.